important case. Mainly with respect to disqualification of the MLAs and MPs. One important case is Lily Thomas case. MLA disqualification, same applies to the MP also. But the original case is with respect to MLA disqualification. Lily Thomas case of 2013 by the Supreme Court. What is this judgment? Listen. In Representation of People's Act 1951, the Representation of People's Act is very important for the sake of providing the qualifications and disqualifications for the people's representatives. What should be the qualifications, what should be the disqualifications for the sake of MLAs and MPs. 8th section is very important. In section 8, there are 4 clauses are there. 8 clause 1, 8 clause 2, 8 clause 3, 8 clause 4. 8 clause 1, 8 clause 2, 8 clause 3 talks about if any elected member or any person who is aspiring to contest the elections, if got punished, if got convicted, convicted means who got punishment, hence proved is called as convicted. Who got discharged of his offences is called as acquitted. Who got discharged of his offences is called as acquitted. Who got punished under a case or an offence is called as convicted. So, section 8 of clause 1, 2, 3 of the Representation of People's Act 1951 will tell that if any person is convicted in some of the offences which are mentioned in the section 8 of clause 1, clause 2, clause 3 will be disqualified at that particular moment itself. And he is not allowed to contest the elections also, like POCSO, prevention of sexual offences against the children, or rape, or murder, sexual assault, or section 420 cheating. If this, under this sections, if offences are made and proved in the court of law, then he will be disqualified and he is not allowed to contest elections under section 8 of 1, 2, 3 clauses. But immediately there is one more clause which is called as clause 4. 8th section 4th clause. It tells that when he got convicted from the lower court, when an MP or MLA got convicted under the lower court, within the 3 months if he appeals, within the 3 months when he got the punishment, within the 3 months if he appeals in the higher court, till the judgment is out from the higher court, his disqualification will not be applied. Means he can continue as MLA or MP. They punished by 8, 1, 2, 3 and immediately in 4th they told that if they appeal in the higher court, then the disqualification will not be applied, the disqualification will be continued if the higher court also convicts him. By the time the 5 years will be completed, he will enjoy the MLA, he will enjoy the MP, how much he want to earn, everything he will be done. So this section 8 clause 4 was being questioned under this Lily Thomas. Lily Thomas is an advocate in the Supreme Court of India, and in this judgment the Supreme Court told that section 8 clause 4 is null and void. If they are convicted by the lower court also, they will be disqualified as an MLA and MP. Why so, sir? Why so? Because criminalization of politics is an issue that affects the very core of the democratic setup. In spite of getting punishment, that means they are proved as criminal, but still they are enjoying like people's representatives. They are going to the Lok Sabhas, they are going to the Rajya Sabhas, they are coming to the legislative assemblies, they are coming to the legislative councils also. In order to stop the entry of the criminalization of politics, the Lily Thomas case is very much important. The disqualification of the legislatures are discussed under this section, and the section 8 of clause 4 was been removed, was been made null and void. If they are convicted, that means immediately their position as an MLA and MP will be removed, disqualified by the effect of the judgment, in 2013. A lot of MPs got affected because of this judgment. Lalu Prasad Yadav, that is Lily Thomas. This is the same content which I explained to you.
So disqualification means in future also they cannot start.
Yes, very good question. So here what happens when, for example, if they got a punishment of 2 years, in Indian Penal Code, any punishment is more than 2 years and above, it is called a serious offence. Under Indian Penal Code, if the punishment is more than 7 years, it is called as heinous crimes. So, for the serious crimes, 2 years and above, if the punishment is there, then they will be disqualified under section 1, 2, 3 clauses of 8. After they get the punishment, after they complete the punishment, after the completion of the punishment, 6 years. From that day onwards, 6 years, they will be not allowed to contest the elections. After 6 years, they can be allowed to contest. So, according to the Lily Thomas judgment, when they got convicted, immediately disqualification will be applied. They will be removed as an MLA and MP. Till they pursue the punishment or till they appeal in the court, still they will be disqualified. If the court dismisses, higher court dismisses, then again he can contest the elections. But if higher court also convicts him, then his punishment should be completed. After the completion of the punishment, from that day 6 years after, he can contest the elections. That is Lily Thomas case. Next case is Ram Babu Singh Thakur versus Sunil Arora and others, Supreme Court case of 2020. What is this case? Recent case, 2020. Any criminal antecedent, any cases are there with respect to you, criminal cases are there on the contestant or a person who got elected, he need to provide that information to the public. Already a case was been booked on me, section 420. Please people before voting just know about me, he should declare. There is a rowdy sheet opened on me. There is a Gunda Act on me. Please public know about me that already I am a criminal. If you want to vote, you can vote. In that way, open declaration need to be given by the legislatures. Supreme Court in February 2020 passed another judgment whereby all candidates both at the state and central would have to publish their criminal records if they want to stand in. So they have to tell that I am already a 420 convict. Please know about me. I am already a criminal person, but still I am contesting for the elections. If you wish, you can vote for me. Lot of cases are there on me, but I am contesting the elections. If you can vote, you can vote for me. So it's genuine person, he is very genuine person. So he is coming up. Genuinity at the peaks that yes, I am a criminal, but still I am contesting the elections. I am giving you open declaration. I am very transparent. Yes, that is what the judgment is telling. So this is Ram Babu Singh Thakur versus Sunil Arora and others, Supreme Court case. The next is anti-defection law. 10th schedule of the Constitution. Originally 8 schedules are there. 10th schedule of the first Constitutional Amendment Act is called as 9th schedule of the Constitution. 52nd Constitutional Amendment Act is called as 10th schedule of the Constitution. The 10th schedule of the Constitution talks about defection. If any person wins the elections by one symbol, after winning the election, jump the party. So he is defecting. He is cheating the public. Why? Because I voted him by seeing his party symbol. He belongs to one political party, but after winning elections, he jumped the party. That means he cheated the voter. Then this defection law, which is called as anti-defection law, will come into existence. Means whoever, defection means cheating. Whoever cheats, for them there will be an anti-mechanism which is called as anti-defection law. The 10th schedule of the Indian Constitution, popularly referred to as anti-defection law, was inserted by the 52nd Constitutional Amendment Act in 1985 by the Rajiv Gandhi to stop Ayaram, Gayaram. There was one popular politician. In the morning he was one political party, afternoon another political party, by the evening another political party. So there is a jumpings are happening. So in order to stop that jumpings, or in order to shift the political, in order to shifting the political parties itself, in order to keep a step, or in order to stop it, there is one law called as anti-defection. How we are changing mobile phones nowadays? The RAM is changing the political parties. In order to stop that defection, there is an anti-defection law. Provisions. So mainly it talks about disqualification. When an MP or an MLA can be disqualified or will be disqualified. To the point. Number 1. If an elected member gives up his membership of a political party voluntarily, I won from one political party, but I am giving up my political party and I am jumping into another political party voluntarily, then disqualification will appear. Why? Because if you want to come out of the political party, please come out of the MP also, come out of the MLA also, or you resign completely and again contest for the elections. But after winning on one political party and choosing another political party after the winning is nothing but cheating the public. Disqualification. If he votes or abstains from voting in the house contrary to any direction issued by the political party, there is a concept called as whip. Every political party will give the whip, means direction, obligation, compulsory obligation. All the political MPs or MLAs of our political party, we are giving the whip, everyone vote for this issue. But if someone is not following the whip, means not following the order of the political party, then also anti-defection law will be applied. Second. Third. If any member who is independently elected joins any party, I told that I am an independent person and I contested the elections. Everyone thought that I am independent and they vote for me. And after winning, I jumped into another party. That means cheating the public. A independent person also, when he jumps into another party, he will be disqualified. Or any popular party person, if he resigns from his party and joins another party also, he will be disqualified. If any nominated member joins any political party after the end of 6 months, this one, nominated members, like Anglo-Indians till 2020, or in Rajya Sabha nominated member, or in the Legislative Council nominated member, he can change the political party within the 6 months. Within the 6 months, he can choose any political party and he can go there. Mainly it is an issue with Anglo-Indians in the Lok Sabha and the Legislative Assembly. But this thing is not there now. Why? Because Lok Sabha and the Legislative Assembly, now there is no nominated members for Anglo-Indians. So now it is only with the Rajya Sabha and the Legislative Council. They are given the time period of 6 months. Within 6 months they can choose any political party and they can go. But after 6 months they are not allowed to change their party. If they change after 6 months, they will be removed. The decision on disqualification questions on the ground of defection is referred to the Speaker. And the Chairman of the House means the Chairman of the Legislative Council and the Chairman of the Rajya Sabha, the Speaker of the Legislative Assembly in the state and the Speaker of the Lok Sabha. Their decision is final when to apply this anti-defection. Exceptions under anti-defection law. In the situation, 2/3 of a political party members, they choose to resign from one political party and join another party. 2/3 is a very big number. So it might be some genuine case. So anti-defection law will be not applied if 2/3 members of one political party jump into another political party. Why? Because 2/3 members means, for example, if 100 members are from one political party, 66 members are going into another party means a very big thing. So there is something problem with the political party only. So it is exempted. In the situation where 2/3 of the legislatures of a political party decide to merge into another party, neither the members who decide to join nor the ones who stay with the original party will have his disqualification. Means who are going to change the party and who are present in the party also will not face any disqualification. Why? Because the logic is there might be some genuine problem with the political party. That is the reason 2/3 members are changing the party. Is the decision of the presiding officer subject to judicial review? Till recently, till 1993. Why? Because 1985 Anti-Defection Law was being made by the 52nd Constitutional Amendment Act, and in 1993 a judgment was being out which is called as Kihutu-Holahan case. Kihutu-Holahan case, whereby the decision with respect to anti-defection law of the Speaker of the Assembly and the Lok Sabha and the Chairman of the Legislative Council and the Rajya Sabha was being final. Means if we decide to disqualify, he will be disqualified. The MP or the MLA will be disqualified. But in the Kihutu-Holahan case, the Supreme Court iterated that the judicial review is a basic structure doctrine. Speaker will not have the power to supersede the power of judicial review. Hence, the decision of the presiding officer is also subjected to judicial review. The Act provided that the presiding officer's decision was final and could not be questioned in any court of law, but in Kihutu-Holahan case of 1993, the Supreme Court declared this provision as unconstitutional on the ground that it seeks to take away the jurisdiction of the Supreme Court and the High Courts with respect to judicial review. So now, the presiding officer's decision with respect to anti-defection or disqualification of the members of the legislatures is subjected to judicial review. Does the anti-defection law affect the legislature's ability to make the decisions? We have to do like this, questions and answer. Question, then we will understand properly. Does the anti-defection law affect the legislature's ability to make a decision? Yes. My political party is not secular, but I am secular. They made a decision which is against my conscience. It is against my wish. It's against my conscience, but they gave a whip. But I don't like it. But under anti-defection law, if I don't follow the whip, then I will be disqualified. So what it is making, it is forcefully making me to not work according to my conscience. So my individual liberty is compromised. My individual liberty is compromised. My free will is compromised. The anti-defection law aims to maintain a stable government by ensuring that the legislature do not switch sides. This is a positive. So for a stable government, anti-defection law is good. But this law also limits the legislature from voting according to his conscience and electorate's interest. In my constituency, I promised them and I became success. Now the political party is working against my constituency's interest. So sometimes I might compromise with respect to my conscience, my free will, or my electorate's interest also. But however, for a stable government, there is a requirement of anti-defection law.